जहां भी जाते हैं बगावत की बात करते हैं। आप कोड ऑफ क्रिमिनल प्रोसीजर की बात कर रहे थे और कह रहे थे कि बड़ा अच्छा कोड है। यूएपीए की बात हुई, पीएमएलए की बात हुई, और मोहन गोपाल जी ने बताया कि केरला में क्या कर रहे हैं। But I have a little problem with all this. The problem is the following. When we adopted the Constitution of India, it was based on the 1935 Act. When we adopted the criminal laws, it was the same IPC, the same CRPC. When the British had this provision that you can arrest anybody on the basis of suspicion, why did the British do it? Because they wanted to quell dissent. They could just arrest anybody they liked. They didn't want people to speak up. They didn't want people to talk against the British government. And so many atrocities were committed based on this provision. I have a problem with this provision. How does it pass the test of constitutionality? You cannot be deprived of your life or liberty save in accordance with procedure established by law. And what is that procedure? Suspicion. I can suspect anybody I like. What's the basis of that suspicion? That's subjective. It can't be objective. There is no procedure to make it objective in the Code of Criminal Procedure. So I have a fundamental problem with the genesis of criminal procedures. And nobody has challenged it so far. And I don't know why. You prosecute under PMLA, you arrest him on suspicion. Then he can't get bail. You tell the magistrate, I suspect him. He says, what's the evidence? He says, I'm finding out. You had, under the code, you have 14 days. Now it's 30, 60, 90. It's up to 90. That, of course, law will not come into effect till 1st of July, but that's another matter. Question is, how does the magistrate decide that this suspicion is based on facts which can be demonstrated in a court of law? I don't know why you suspect me. I suspect you because you were there. Oh, I suspect you because you gave a speech in Mumbai. Oh, I suspect you because I know you are part of a conspiracy. Why do you suspect me? Because you made a phone call. This is the kind of evidence on the basis of which the prosecution relies to deny you liberty. So I think it's about time we started testing, questioning the very genesis of this code. And it will require a lot of public debate. Because if you arrest me, I don't know what the facts are. He doesn't tell me what the facts are. And even if the grounds of arrest are supplied to me, they are not enough for me to defend myself. And in some of these codes now, and some of these PMLA and UAPA provisions, especially PMLA, the judge has to be convinced that you are not guilty of the offense. Well, I don't even know what the offense is. So how do I convince the judge that I am not, or he gets convinced that I am not guilty of the offense? I don't know the facts on the basis of which, on suspicion, somebody has arrested me. So that's the first point. that we need to look at as a matter of constitutional law. Is suspicion enough of a procedure? Or there is something else that needs to be elaborated and demonstrated for someone to have a reasonable cause for suspicion? What are the parameters of that? Will the court elaborate those parameters? The absence of which, according to me, this provision is unconstitutional. That's point number one. I'm sorry, I'm going to the genesis of all this because we've been discussing all these laws. Point number two. In which country do you get police remand? What do you mean by police remand? Means on suspicion, of which I don't know the facts, I'm going to be arrested by the police and kept for 14 days. What's the rationality for that? In which jurisprudence do you get police remand? No jurisprudence. In liberal countries, you investigate first, then you arrest a person, and you demonstrate that. In our country, you arrest first and investigate later. So this concept of police remand, I do not understand as a matter of constitutional law. Because police remand, what does it mean? That I will be in the custody of the police, incommunicado to anybody else. Why should I be incommunicado? I will not be told of my grounds of arrest because the charge sheet will be filed much later. I'll be asked all kinds of questions which have no relevance to the incident. And this is especially true in some of these very draconian laws. For example, take the PMLA. I'll just give you an example. You start asking him, you have no evidence against the man because for whatever reason, and I don't want to, give the reason for this because we all know why people are arrested. But what happens is that you call a person, arrest him under PMLA, and you start questioning him. Now, I want to know, that's the third issue I want to raise. When you call somebody in PMLA for recording his statement, you don't know, the person who is called doesn't know in what capacity his statement is being recorded. Is he a witness? Is he an accused? He doesn't know. You just send him a notice. The ED sends him a notice saying, please come appear on such and such day at such and such time. I write to him and I say, look, tell me what the reason is. He said, no, you have to come. I won't tell you what the reason is. So what kind of procedure is that? Is somebody not supposed to tell me before arrest as to what's the reason why he wants to call me to arrest me? Is someone not supposed to tell me why he's calling me, in what capacity, with respect to what incident, with respect to what transaction? Am I not supposed to know? Have I no right to know? I'm not talking about cases where there is a murder and there are eyewitnesses and you go to the spot. That's a separate cup of tea. I'm talking about these so-called economic offenses and so-called offenses against the state, the PMLA, the UAPA. These are special laws with special provisions, draconian provisions. According to me, entirely unconstitutional. So what does a citizen do? He goes to the trial judge says, abhi to taftish honi hai, abhi to investigation honi hai, kya, kahe ko, are grant remand, 3 days, 5 days, 10 days, it will be 60 days, 90 days. The investigation will go on. And now it's a very interesting thing. Now they say, under the new laws which will come into force, that you can have a gap. आपको 2-4 दिन के लिए रख लिया, फिर 2-4 दिन के लिए छोड़ दिया, फिर 2-4 दिन के लिए दोबारा रख लिया. No rationale for it. So, That's the third problem. I want to know in what capacity I'm being called. Why do I want to know? If I'm being called as an accused, I can say I'm not going to answer any of your questions. If I'm being called as a witness, I must know why, in which capacity, what incident, what's my role. And as a witness, I have to go and I must go. But what they will do is they will arrest me first. In the meantime, record my statement and use that against me, knowing full well that you're calling me as an accused. It's absurd. Makes no sense. I mean, see, law is common sense. Law is nothing. You guys think that, we are learned lawyers. No, we're not. We're just simple, ordinary people who understand simple, ordinary things of life. And you apply them to a situation. That's law. When you read a statute, you use simple words, try and understand the basis of those words used in the statute and find out whether it's consistent with my constitutional rights or not. It's as simple as that. Right? Now, third issue, another issue. Under some of these special acts, you don't need to keep a diary. In the PMLA, UAPA, you don't have to keep a diary. Under the Code of Criminal Procedure, you need to record in the case diary every day what happened, who you visited, where you visited, which statement you recorded, all that stuff. No such thing. In other words, the more draconian the law, the less the protection. Is that consistent with the Constitution? How do the two match? So, I think that we as lawyers should start thinking of basic issues. Raise these basic issues in court. We take the law for granted, take its constitutionality for granted, and then we argue. It's an entirely wrong approach. Luckily, we have a constitution which has given us some rights. We must start with the proposition that this law, is it consistent with my rights under the Constitution? If it is, we collaborate. If it is not, we challenge. And we must have a fresh look at these things. And as lawyers, we must form groups who understand the nature of these laws, the impact of these laws, the consequences of these laws as they are put into action, and all that needs to be done by us. That's how, and that's why we need, through YouTube, through the social media platforms, this to percolate down to people, because unless you reach this information down to people, they will not know. Now, that's all I wanted to say just on the law. The fundamental issue is, if the system has no integrity, you can twist any law in the manner that you like. We've reached a stage in this country where systems have no integrity. The police has no integrity. Institutions have no integrity. And when I mean integrity, I don't mean individual persons. There will be individual persons in any system who are phenomenal human beings, who will try and protect you. I mean, as an institutional structure, this nation is losing its embrace to integrity. Now, when that happens, and if the police functions in accordance with the direction of the government in power, whichever government that may be, no law can protect you. So, the fundamental question that we must ask ourselves is, how do we ensure that people with integrity are part of the system? And there the problem of politics and money power comes in. This whole problem of these laws and corruption and money use and bonds, electoral bonds, and all that has come about. Why? Because in 1993, we liberalized the economy. We couldn't do without it, and we can't do without it. This liberal economy brought huge amounts of money in the private sector. So in fact, we needed more systems in place to make the actions of government accountable, right? We forgot to do that. So the corporate sector, the big business had huge stakes in the economy, and they were willing to barter away their integrity. And people who were willing to, at the helms of power, were willing to barter away their integrity, right, for money. The electoral bond scheme was actually meant for that, which is Prashant beautifully argued that, look, we have a right to know who is given what. So, one, good people must get into politics, must risk that journey, as some of us have done. And the middle class must raise its voice, which has succumbed. It's lying prostrate before the powers that be. 3, lawyers, no matter which political party they may be inclined towards, must speak in one voice, because you're a lawyer first and a politician later. Why? Because your duty is towards the people. This is a service industry. It's not a business. We've made lawyering as a business. How much money will I earn today? And the moment you do that, you're not a lawyer. You're just as good or bad as any other businessman. And it is the lawyers that can lead from the front. And I think that these gatherings should inspire us to actually take the message across the country. We need to spend some time giving up our time for going around the country and explaining that we as lawyers can lead the nation as we did when we brought freedom to this country. Let us march along for yet another freedom that we need and require and espouse for and look for.